Thank you for having me again. Good afternoon, everyone. Chair Crop, members of the committee. For the record, my name is Inessa Hartman. I have the honor of representing House District 40, which includes Gladstone, Oregon City, and parts of unincorporated Clackamas County, and I am very honored to be here today in strong support of House Bill 3582 and its -1 amendment. You will soon hear from two brilliant attorneys today who bring deep expertise to this issue stemming from decades of representing thousands of survivors in Oregon. Aaron Olson will speak to the broader context of the base bill and how this reform fits within a growing national movement to eliminate civil statutes of limitations for sexual assault and abuse. Peter Jancy will explain the legal nuances of the -1 amendment and why that one word, knowingly, has quietly become one of the biggest obstacles some survivors face when trying to hold institutions accountable. I am here to speak why this bill is necessary, not in technicalities or in theory, but rooted in the reality of survivors and victims. Because in reality, our laws, our systems, our lack of investments are failing them. And let me explain what this bill does. Right now in Oregon, if you were sexually assaulted as an adult, you have 5 years to file a civil lawsuit from the time you discover or should have discovered the connection between the assault and the injury it caused. If you were sexually abused as a child, you have the same 5-year discovery window or until you turn 40. And that may sound generous on paper, but in practice, it doesn't come close to honoring the long, painful process survivors go through to even begin speaking about what happened to them, let alone navigate a cold legal system that is not trauma-informed. House Bill 3582 eliminates those time limits. It recognizes that there is no one-size-fits-all timeline for healing from sexual assault or child sex abuse. This bill follows the lead of 11 states that have already eliminated those time limits, ensuring survivors can pursue justice on their terms when they are ready. These states include Arkansas, Louisiana, Colorado, New York. I will note that this bill is not retroactive. It applies to all future claims and to cases where a victim hasn't yet discovered the connection between the injury and the abuse. But to the advocates listening, I am committed to revisiting retroactivity in the future after working to figuring out a way to do that without flooding our courts. That alone is a meaningful and necessary change, but there's another part of this bill that deserves just as much of attention, and that's the -1 amendment. The -1 amendment removes the word knowingly from ORS 12.117 and ORS 12.118, the statutes that allow extended timelines for civil claims against institutions that allowed or permitted abuse. And you may be wondering why one word matters so much, but let me tell you, it matters a lot. Powerful institutions have weaponized that single word to argue that unless a survivor can prove that the organization knew the perpetrator was abusing them personally, they shouldn't get their day in court. Not that they ignored red flags, not that they had multiple prior reports, not that they knew the person was dangerous. None of that is good enough if they can convince a judge that they didn't knowingly allow the abuse of that particular victim. And we have seen this play out in case after case against churches, against private schools, against national youth organizations, and against doctors and hospitals. And in nearly every one of those cases, the survivor had the courage to come forward, and the defendant tried to slam the courthouse door shut using that word knowingly. This interpretation of the knowingly language seeks to impose a standard that does not exist in many other areas of negligence law. If you're hurt in a car crash or a workplace accident, you don't have to prove the company knew you personally were going to be injured. But for sexual abuse survivors, for child abuse survivors, defendants are arguing that the law has carved out a higher bar, and to me, that is unacceptable. This amendment simply levels the playing field. It restores the original intent of the statutes, which were meant to give survivors more time, not less access to justice. As with the rest of the bill, the -1 amendment will not apply retroactively. We need to be honest about who benefits from our current system. And to me, sometimes that is bad actors who are betting on silence and delay. Institutions that have knowingly, yes, knowingly, turned a blind eye to credible reports of abuse and moved perpetrators around rather than moving them. They know that if they can run out the clock, they'll never have to answer for what they allowed to happen, and our laws are letting them do that. Let me be clear, this bill is not about punishing people or institutions who made one mistake. This is about holding accountable those who made repeated choices to protect themselves instead of protecting children, patients, and students, and other vulnerable people. And we cannot allow Oregon to remain a state where survivors are told you took too long or you don't have enough proof, when we know the real reason they were denied justice is because the law was written in a way that worked against them from the start. And I've said this before, that I did not run for office just to pass laws, but I ran to center and uplift the voices of people who have been silenced and ignored for too long. And that's exactly what this bill is about for me and for many survivors. And with that, I urge your support of House Bill 3582, and I really thank your opportunity for hearing this bill, and I will pass this along to the next panel of experts.